Welcome back, everybody, to the Law and Crime Network. We are preparing for trial to resume in the Sean Great case. If you would like to continue watching that, it just came back with break. It appears moments ago. You'll have to switch over to our dedicated feeds on lawandcrime.com to watch that, because we are going to bring you an exclusive interview right now with one of the jurors in the Tex McIver murder case, which resulted in a conviction not too long ago on felony murder charges, as we brought you live here on the Law and Crime Network. Lakeisha Boyd was juror number 61 in that case, and she joins us now live. Lakeisha, thanks a lot for joining us. We appreciate it. We appreciate you sharing your perspective, sitting on a jury panel for more than 20 days in a high-profile murder case. I have to start off by asking you, was this shooting intentional, and why?
Me personally, I don't think he intended to shoot his wife, but I think he intentionally to shoot someone. So that was the recklessness in the case.
Explain that to me. You just said recklessness in the case, but the charge that you convicted the defendant of was...
one is aggravated assault, which consists of a Georgia law that if you convict of aggravated assault, that felony murder comes into play. The felony murder is due to a crime being a felony being committed, and it was a death that was caused by a felony being committed.
Yeah, the underlying crime, the aggravated assault, means that he intended to violently injure his wife, but you didn't agree that he intended to kill his wife, because that would have been malice murder.
Malice, yes.
So he intended to violently injure his wife, but didn't intend for her to die. That was the legal charge. How did jurors arrive at that?
We all went over the case and looked at everything that we was presented, and we all went back down to the car with the gun, and we all came back up, looked over our notes, and we all put our heads together, and we came up with that it was an aggravated assault, and also, like I said, by Georgia law, a felony. That's where felony murder fell in.
Yeah, but see, so what you found is that he wanted to violently injure his wife, but that he didn't want his wife to die. So how did that fit in with the state's case? Because the state was pretty clear that he wanted her dead, but you didn't believe that he wanted her dead.
They didn't present to us. They said that he murdered his wife. They didn't present to us that he murdered her. They did not present murder. They presented us with like aggravated assault, and being as though you cannot put in involuntary manslaughter with aggravated assault, because according to the Georgia law, you will have to find felony murder.
If you believe that the death was an accident, so ultimately
it was not an accident. We do not think it was an accident.
You don't think the death was an accident?
No.
You don't think that the death was an accident?
No. No.
So if it wasn't an accident, then why not malice murder?
We don't think that they proved to us that he wanted to murder her. They did not prove that to us.
But they did prove that he wanted to violently injure his wife. That's what an assault is an intent to violently injure. Yes. So he wanted her hurt, but the state's whole theory of this is that he wanted her dead so that he could get control over her money, her property, take control of what she was devising her property to under her will. How would he have taken control of her money, taken control of her property, taken control of where that property went on ultimately both of their deaths if she was still alive?
He wouldn't have been able to. He wouldn't have been able to.
So how did the violent injury part of this fit in with the case? That's what I'm trying to drill at.
I understand where you're trying to drill at. My thing is, like I said, they presented to us a case where as though bodily harm was bodily harm was intended, and the woman died of aggravated assault. So therefore, that's where the felony murder come from. I don't know if y'all are familiar with the Georgia law, but
Yeah,
that
I
is
have.
the
I'm
Georgia
a
law.
lawyer. I've read the law. I've read the cases. I read the cases
Right.
that interpreted the law. So what you found is that he intended to violently injure his wife. And that she accidentally died because he wanted to injure her, but he didn't want her dead. That's the aggravated assault part of it. And that because she
Right.
accidentally died, it could allow a felony murder conviction. I understand the logic of it, but I'm trying to figure out, the state kept saying that he wanted her money, that he wanted her property, and that he needed her dead to get out from underneath some of these debts and whatnot. So if he only wanted to violently injure her, which was your view, then legally, based on the verdict that you delivered, how would he have been able to do that according to the state's theory of the case from the factual standpoint that they had argued all along that he wanted her dead to get at the money? How does a violent injury allow the state's theory of the case to stick?
Because a gun don't just go off. A gun don't just go off.
So break it down.
It does not.
Break it down for us. What do you and your fellow jurors think happened in that car that night?
Well, we was able to go back down to the car with the gun. We was able to take the gun back down. And we had one sitting inside the driver's seat, and one of us sat inside the seat that Tex was sitting in. Nobody could sit inside the passenger seat because you had the trajectory going through the front seat. So with one of us sitting inside the back seat, we had to line the gun up with the trajectory and see if he was actually pointing the gun at her back. And everybody was able to place the gun either on their thigh or somewhere along their leg for it to match up with the trajectory. So he had to be pointing the gun at her back.
Well, did he intentionally pull the trigger then? The state said that he pulled. The defense said that he pulled the trigger. They admitted that, but they said that it was accidental. That he was waking up. That in the process of waking up, he was startled or whatnot, and there was just enough pressure applied to that trigger that it went off. But you don't think that's what happened, right?
No.
So
because that's where the recklessness comes into play. You don't point a gun at nothing that you do not intend to shoot.
So
whether it's loaded or unloaded.
So recklessness is. You had the chance at a lesser included charge here, recklessness. You had involuntary manslaughter due to reckless conduct. You keep using that word reckless. Why didn't you go for that charge of recklessness? Because you had that chance.
No, not because we've seen more than just recklessness. We've seen more than just recklessness.
What more did you see than recklessness?
Again, you do not point a gun at something that you do not intend to shoot. Whether it's loaded or unloaded, you do not point a gun at someone like that.
So you don't buy that he was falling asleep at all? You think that he purposefully pointed that gun that way and pulled the trigger?
Yes.
But that he didn't intend to kill his wife?
I don't know what Mr. McIver's intentions was, but I know that you do not point a gun at something that you do not intend to shoot, whether it's loaded or unloaded.
So let me.
No, I do not believe that he was asleep. Even if he was asleep, you still know that you had a firearm in your hand.
So let me ask this.
And your hand is on the trigger.
Do you believe that he meant to kill his wife or injure his wife?
Yes, I do.
I'm not sure if I can hear you. I might have lost. I might have lost sound here. I'm sorry about that. I think things are okay on your end. Let me try to continue through this. So take us back into the jury room. It took a while for deliberations. You asked a lot of questions of the judge. What was going on in the process back there in the jury room with your fellow jurors?
They gave us a pamphlet with explaining all the charges. And some of the jurors was confused by some of the scenarios that they had on there. So we were sending questions back out to the judge, and he just was like, read through the pamphlet, and your answers will be answered. Like, he couldn't guide us in no type of way. Like, all he kept on saying was reread the pamphlet and go over your evidence.
Let me ask you another question here. So that's what was going on in the jury room. How did you get along with your fellow jurors? What were they like? Did they get along well? Did people really disagree back there? How did that all go down?
No, we got along very great. We got along very great. We was like all friends, but we all had our ups and downs. We had our ups and downs, but for the most part, we all got along.
Interesting. So when you take that into the experience, certainly that's a key part of it. I got to ask you, what led to the decision to actually go and look at the car yourselves? I mean, it's almost like you were kind of conducting your own trial behind the scenes back there.
We had to go through the evidence with a fine comb and make sure that we wasn't missing nothing.
Well, I got to ask a question about that. I mean, the state has to prove its case beyond a reasonable doubt. And if you're back there conducting your own experiments, then how is it that the state proved its case beyond a reasonable doubt if you felt like you had to seek the answers yourself?
It wasn't that they didn't prove to us. It was that when we went down to the car the first time, we went broken down into two groups. And the first time when we went down to the car, we didn't have the gun the first time, and we only could go through the cars, and then we had like news people and everything down there. So the second time when we went down there, we was able to take the guns, and the 12 jurors itself was able to go down instead of all 15 of us as a group.
No, I understand that, but the burden of proof in a criminal trial is proof beyond a reasonable doubt, and the state has to provide you with enough information to make the decision on your own. So that you felt the need to sort of look for your own answers here. How does that? It wasn't more so that we was looking for our own answers. We just wanted to go back down to the car the second time with the gun, being as though we was only able to go down to the car the first time without the gun. We wanted to see, being as though they had the two experts on stand, and they kept one expert said that the gun was like this, and the other one said that it was like this. We wanted to see where would the gun had been. So therefore, one of the experts we found that one of the experts was right on what he was saying, that it had to be somewhere along your leg. Because the one guy said that the gun was just pointing right there, but we wanted to see where on your leg would it had been. So that's what you were looking for there. I've heard that there were some people on the jury who had a lot of experience and expertise with weapons. What did they bring into the jury room?
No. It wasn't that they were experts or expertise. They own guns.
Okay, gun owners.
Yes, some were gun owners. They were not experts or expertise or nothing like that. No, none of us were.
What did they ultimately bring to the deliberations?
Really, that guns don't just go off. Like, they have guns too. One of the men had a revolver himself, and revolvers just don't go off by themselves. So
let me ask you this, though. When the state's own expert, so the prosecution expert, is up on the witness stand, he's working with the mechanism of the gun, and he accidentally triggered it when he was on the witness stand right in front of you, and the defense played that clip a couple times during the closing argument. So you don't believe a gun can go off accidentally, but didn't that prove that the gun can go off?
He was playing. That man was playing with the gun on the stand. He was playing with the gun. So basically, you're trying to say that McIver was playing with the gun in the back of the seat?
Well, I'm not necessarily saying that. I'm asking you what you found. I mean, the defense said that his finger was on the trigger, and Danny Jo Carter said she heard some clicks before the shot went off, and she wasn't quite sure what they were. So, I mean, is it possible that he was, waking up from being asleep or whatever, and that something there went off, that the bag was wrapped around part of the gun, and his finger applied just enough pressure to it?
No, I don't believe that. No.
So you think that he purposely pulled that trigger back all the way with an intent to violently injure his wife, but that he in no way wanted her dead?
Yes, I do.
So what was the motive then?
It could have been the finances. It could have been the stress.
Well,
of
but
him
if she's alive and she's injured, then how would that have helped his position financially? Wouldn't that have just racked up more bills?
It would have, but he would have been in control.
So he wanted to perhaps incapacitate her. That's it.
I don't find that he wanted to capacitate her. He did what he wanted to do, and that was for her not to be here. But it did not go his way.
So let me ask you this. This is a mandatory life sentence ultimately. Is that the punishment that you feel and that your fellow jurors feel fits the crime?
I did not know it was a mandatory life sentence. Felony murder, I did not know that. But if that's the sentence for that crime, then yes.
So you think that that punishment fits the crime?
Yes.
So as we move on here, you sat on this panel. You were there for more than 20 days as part of this. You heard a lot of interesting testimony.
26 days.
One piece of it was that the prosecution was insinuating some kind of inappropriate relationship between Tex McIver and the massage therapist. A lot of people picked up on that during the state's case. But then when that massage therapist got up on the stand, she said there's nothing inappropriate going on. How did you and how did your fellow members of the jury take that?
They were basing it around a pair of boots. We still don't know the size of Miss McIver wear. That was never really pressed into it. And as far as she's a massage therapist put their hands on people. I didn't see nothing being sexual in between them two.
Did that cut into the state's credibility, though, that the state was trying to probe at that, but they ultimately had to walk it back?
Yes. Because, like I said, I didn't see where as though there were any type of affair going on in my eyes. I didn't. It was all based upon one of the witnesses saying he went to the ranch and she had on a pair of Diane boots.
And there was some evidence that some of those boots may have just been moved to sort of a what you could say is a public boot rack, I guess, where people could just grab whatever boots were there. There were dozens of boots there that anybody who was showing up at the ranch could use it.
Yes.
Was there any one piece of evidence that really jumps out in your mind that this was it, that this is what you relied on to make your decision?
He was in financial distress.
So
his income was dropping. His income was dropping dramatically.
Well, that's true, but I mean, he was 72 years old. It's not uncommon for somebody at that age in a law firm to sort of transition into more of a retirement role.
I understand that. I understand that truly. But at the same time, like I said, his income was dropping dramatically, and he still was living outside his means.
It's an interesting theory. It's certainly an interesting theory. So he wanted to violently injure his wife, but not kill her so that he could get control over their finances.
Correct. And that's just the theory. Because we never know the correct answer.
But the state, all through the trial, had said he wanted his wife dead to get control of the finances, and you don't believe that?
Some part of me, like I said, he was in financial distress. He wanted to be in control. He even said in one of his interviews that he likes to be in control.
What do you make of some of the other elements of this, that the neighborhood that they were entering was somehow dangerous? I've not spent very much time in Atlanta myself. I don't understand the area, have barely spent any time there. Did people think that was sort of a bogus story that Tex McIver was saying, that he felt threatened once he got off the highway and that he went into this neighborhood and that neighborhood was somehow so dangerous that he needed to get that gun out?
I'm not from Atlanta neither, but I have been down that way. And I also went with Channel 11 live last night, and we went down that way. It's a regular neighborhood. You got homeless people throughout Atlanta. That's not just the only place that has homeless people. You have homeless people all over Georgia, underneath bridge, on sidewalks, on the side of people's houses. Why did he feel threatened? I don't know. But would I have what I felt threatened? No. They're homeless people. That's their home.
And what did you make of some of the other evidence here that that some people on the ranch were asked to take Danny Joe Carter home? Did that play into things? Apparently, the state's theory is that Tex McIver wanted to be alone with his wife that night. Did that play into deliberations or not?
We talked over that. That took like about an hour of our time inside the juror room, because Danny Joe never rode with them before, and they asked Tex asked Danny Joe to ask Tanner to take Danny Joe home, but we was also saying that Tex asked Tanner to take Danny Joe home because they just was down in that area the weekend before, the night before, or why did he ask him?
I got to ask. Okay, so I want to ask a couple of other questions here, because you came back with a number of questions for the judge. At one point, there was a question as to whether you could acquit on all of the top charges and convict on that count number 5.
No. We didn't say acquit. We never said acquit. We wanted to know if it was a chance that we couldn't all agree on count 5, 1 through 4, could we convict on count 5? And they said yes. Each charge is individually has its own category. No problem. But that was just from 1 or 2 of the jurors that wanted to ask that question. You can't say, oh, we're not going to ask that question as a group. Everyone has their own opinions, and everybody wanted questions answered. So
were there
whoever had a question, we would send it out.
Okay, so in other words, were there a couple of people back there in that deliberation room who were considering not guilty, not guilty, not guilty, not guilty, and then guilty on influencing a witness? Was that at least the opinion of a couple?
No. They just wanted to know, because when they said that a couple of the charges, you couldn't get one charge without getting another charge, so they wanted to know, like, basically, okay, well, if we get this charge, are we allowed to do this charge? Because of the way the pamphlet that they sent back into the juror room with us is like, you can't get this if you don't have this. So that some of the jurors had questions like, okay, well, if I don't get this and I want this, how does it work? Like, they were basically asking questions.
Okay,
it wasn't never know, oh, we're going to find him not guilty. That was never in our intention. Never.
So it was always going to be guilty of either the malice murder or the aggravated assault and a felony murder. It was always going to be that way?
Yes, it was. Yes, it was. But
so
we didn't see the malice, so that's why we didn't go with malice. We did not see malice.
So how did you define that then? How did you said you didn't see the malice. What did that mean to you personally?
Your service is cutting in and out. They keep on coming up that your signal it has poor connection.
Sorry about that. It might be getting a little bit spotty. We'll wrap up in just a second here, but you said you didn't see malice. So
right.
Why is it that you didn't see malice? What did that mean to you?
They did not prove to us that he wanted her dead. They did not prove that, because the way they were trying to base it around is like that, okay, this is my time to kill her right now. But they did not prove that to us. Like, we asked numerous questions to get us the answer that we wanted, and some of the questions got answered, but the ones that we wanted answered was not answered. They basically picked and choose which questions that they wanted to answer in open court.
Well, I'm going to wrap things up here in just a second. I mean, ultimately, I'll ask one last question, though. Lakeisha Boyd, Juror 61, if we still have you there. You sat on this panel. Did you like it? Did you enjoy being a juror?
I wouldn't say I enjoyed being a juror, but I enjoyed serving my duties.
Okay.
But it's not something that I would say, oh, go be a juror. It's fun. No.
But you're proud that you did your duty.
Yes.
All right, Lakeisha Boyd, juror 61 in the Tex McIver case, which resulted in a guilty verdict of felony murder, aggravated assault, and a number of other charges against an attorney in Atlanta who is accused of shooting and killing his CEO wife. Appreciate you joining us here on the Law and Crime Network, Lakeisha.
Thank you.
All right, we are going to switch back to the Sean Great case in Ohio. That case is still going on today. They're running a little bit past 5 p.m., so we will stay on the air. But Brian Wagner, I think we get to let you go at this point. I'll ask you just quickly, reaction to that interview.
I think she took her duty seriously, and she obviously thought about it a lot. What I found very interesting was her explanation that they believed the state proved beyond a reasonable doubt that Tex McIver meant to intentionally injure and violently injure his wife, but they did not prove beyond a reasonable doubt that he intentionally tried to kill his wife, which was interesting.
That's interesting because, you know, it's, and just to let everybody know, we were just about to switch back to the Sean Great case in Ohio. They are in a sidebar. As soon as they pick up live, we will bring you back to that case. I'll just break this down a little bit. You know, from our perspective, it's like, okay, if the gun was pulled, but there wasn't any intent to hit her, well, that's recklessness, sort of at a maximum. It could also be criminal negligence. But, you know, I'm trying to make logical sense of this because if you're struggling financially, why would you injure your wife but not want her dead?
But motive is not an element of the crime, and you don't need to prove motive.
But the state kept arguing motive. I understand that.
Yes, absolutely. But what the jury has said is maybe you got the motive right, maybe you got the motive wrong. We don't care. What we do care about is this. State, you proved beyond a reasonable doubt that Tex McIver intentionally, violently injured his wife. What we don't think you did is we don't think beyond a reasonable doubt you proved that he intended to kill his wife. And it seems like a very small, slim difference. And
it seems like a huge difference to me because if you buy the state's theory, how else was he going to get full control over the assets and the property? The property only transferred to Tex McIver upon her death. That's what the will is for. Not when she's injured.
The charge doesn't require motive. And so although you're saying if you buy the state's theory, that portion you don't need to buy. And you could still find beyond a reasonable doubt that he intended to violently injure his wife and not buy beyond a reasonable doubt that he intended to kill his wife. And it seems like semantics. It does. But that's what the jury has said unanimously with their verdict.
It's an interesting verdict. I wrote up my analysis of it on lawandcrime.com. For those of you who want to take a look at it, if you haven't seen it yet, it's written up there. An interesting verdict. And that interview, I think, was illuminating. So, Brian Wagner, appreciate you joining us today.
Thank you so much for having me.
And I said we were going to go back to the Sean Great case in Ohio, but they wrapped up, even though we thought they were going to run a little bit past 5. I guess they did, in theory, run 3 minutes late. That's where we are right now. So they are wrapping up. More testimony in that case coming tomorrow. A reminder that we are live here on the Law and Crime Network from at least 9 a.m., until at least 5 p.m. You can continue watching, though. We're going to start replaying from the beginning of the day as soon as we sign off. We will see you back here tomorrow live at 9 a.m. For now, this is Aaron Keller. For everybody here at Law and Crime, have a good evening.